Welcome back to ThinkTech. This is Life in the Law, and we're going to talk about gas today. Gas lighting, more specifically, gas from the top, the affirmative action decision, and other related decisions. What do these decisions tell us about the direction of the court? A lot. Okay. With Avi Soifer, former dean of the William H. Richardson School of Law, now a professor of constitutional law. So, Avi, welcome to the show. It's so important we talk about this because you have more data now, don't we, about where they're going? There's no question about where they're going, right?
Well, the end of last year's term had the two shockers for some people, which were the gun control case, which really was quite remarkable, and then, of course, overruling Roe versus Wade. Not too shocking if you've been following these justices. This time, people seem almost numb to what this court is doing because they just don't seem to care. They don't care about precedent. They don't care about the basic rules of the road. They don't care about the guardrails. They just do what they want to do. Now, those two cases last term were on their face inconsistent, I think. We leave things to the states if it's about guns and the Second Amendment, as we've fairly recently discovered it, but not if it's, the other way around. In overruling Roe versus Wade, we must leave it to the states. But when it comes to guns, well, the Second Amendment is so important that we can't leave that to the states. And we have those same kind of blatant inconsistencies here. It's just amazing what they did. Now, before I start on a harangue, which I hope it will not be, there were a couple good things they did. There were some pleasant surprises. Not many, but there were a few. And I guess the most significant one was in a malapportionment challenge out of North Carolina, where Chief Justice Roberts wrote for the court. And he has been the most active, actually, in finding ways to violate voting rights. Shelby County is the prime example, where he struck down the most important part of the Voting Rights Act from 1965. And he said, well, it worked and it was important, but it didn't keep up with the times, which is a very dubious constitutional theory of validation or invalidation. And then he, a couple of years ago, said, well, we're not going to look at misappropriation, malapportionment, sorry. They don't look at the other one either, which gets to fraud, but malapportionment, because that's just not, we don't have standards for that. There are rights, yeah, but we federal courts, we don't know how to do anything about that. So the name of that case is Rucho out of North Carolina, and we won't get involved. The difference here is it's pretty clear that race was the factor. So there is a little bit of the Voting Rights Act left, and at least when race is the factor, well, even Roberts says maybe you can't use race, and that's for congressional apportionment. The other thing that I was really worried about was there's a case involving the Indian Child Welfare Act, and that is Congress not really fully making up for the terrible things that were done to Native Americans and to tribes, but saying when it comes to kids, we're going to favor the tribes and we're going to favor Native Americans. And there was a challenge to that. The allegation was, well, that's about race, that's racial. And what the court did instead was to say, well, it's really important, and ancestry may be different from race, as was key in Rice versus Cayetano, an important Hawaii case. And so we're going to uphold that. However, they came around at the end of the term and they used Rice versus Cayetano. And suddenly, in the affirmative action case, well, in one paragraph, we go from ancestry to race and Korematsu and Rice versus Cayetano. This is inside baseball, I guess. But what they say is you just can't use race. And you can't use race when it comes to private, so-called, businesses, which are doing commercial things. That's her objection. So getting back to what Jay said, she says, having started being someone who is creative, and the name of the case is 303 Creative, that she does artistic things. And the artistic things is she designs websites. No one's actually in the case saying, please design a website for us. She says, no one's really asked me, and I just started this business. But if they did, if there were a same-sex couple, I would have religious objections, and that's really what she challenged on. And so I wouldn't want to do it. And the court says, well, that's fine. Yeah, Now they change it from religious to being about freedom of expression. And they say the way they granted certiorari, they took the question was, may the state compel an artist to say things that he or she doesn't want to say, or to refuse to allow the artist to say things that he or she does want to say. Once you put it that way, it's about freedom of expression, and we have some good freedom of expression protections over the last 100+ years. Nevertheless, Justice Sotomayor takes it apart in terms of some key cases that they just ignore. So the precedents don't matter, the facts don't matter, and this is flying in the face of what the civil rights era did, which was to say a merchant, a restaurant owner cannot refuse to serve just based on either First Amendment expression or First Amendment religion. You can't say, and many people did in these cases, primarily out of the South, my religion tells me that this is ungodly, and therefore I'm not going to allow public accommodations. Public accommodations go back to the common law. In inns in England, just think about it. If you rode all day bumping along awful roads and you got to an inn, the inn was obliged to take everybody. And that's what the law said. Unless there was someone who was, wildly drunk or something like that, they were obliged to take everyone. So public accommodation law stretches back hundreds and hundreds of years. And now we have an exception to it. Colorado said you have to take gay and lesbian people, and the court said, no, you don't. You don't believe in it, you don't have to take it. And they did it on First Amendment grounds. So it's really shocking.
What shocked me, and maybe I'm being primitive about this, but I remember that you can't have a judicial decision without a case or controversy. And the guy who was supposed to be asking for this cake, he said it many times. I never asked for anybody for a cake. I wasn't involved with them. They're making it up.
This wasn't a cake. This was a design of a website, but it echoes the cake case that you're talking about, also from Colorado. And Gorsuch is the one who writes for the court from Colorado, fancying himself quite the Western man and a friend of Native Americans. But he's not a friend of regulations, and that's kind of the point. How can the state regulate such things as what he says expression? Well, the answer is they can. And people certainly said when they had 16 states that had laws against interracial marriage, they said that's what God told us. That's what the Bible tells us. That was the main defense. So how you can put this together with that, you can't, I think. And that's what Sotomayor does brilliantly in her dissent. But getting back to your point, Jay, there's another case, which is also a ridiculous stretch of the old rules about standing in case or controversy, which is what you're alluding to. And Missouri has a lone organization. Some of these issues are, is it private, is it public, is it quasi-public? And they are actually not in the case. But they say, well, Missouri as a state can be in the case because this kind of quasi-state thing might not make as much money if you allow student loans to be forgiven as the president wants to do. And by the way, they also have a doctrine that they just made up, which is called the major questions doctrine. Now, a doctrine isn't a doctrine because you declare it's a doctrine. It came out of thin air, out of whole cloth, if you will. But now they've done that. They did it in an environmental case recently, and now they're using that. Well, we're going to regulate what agencies can do because they are not democratic. And the question, as posed by you, Jay, is the court democratic? Are they more democratic than an agency? But we know that the majority of these justices don't like agencies. And so they have found a new way to limit them. And so they're saying this is an abuse of presidential power and abuse of agency authority. This is the new world of constitutional law. We don't like something, it's unconstitutional. Find me a case, or even if you haven't found me a case, we'll kind of make one up.
Make one up. That's what it is. We make one up. It's like we'll call the lawyers down and they'll make some statements and then we'll legislate. That's what it sounds like.
I take it you don't like it.
You got it. Well, going to the affirmative action case, is there anything in that opinion that is worthy? Anything? That what they're really doing is calling racism by another name, but it's nevertheless racism.
Well, that's and this gets back to Roberts. He famously said in a case in which there had been desegregation orders in both Seattle and Louisville, he said, you cannot use voluntary class assignment or choice to continue to integrate, because that's using race. And the only way and the best way to get away from using race is not to use race. So the school board, school committee couldn't use race if they were trying to balance. Now, that makes some logical sense, but of course, in what world is race not a factor? What they say in this case is race isn't a factor. And what the new Justice Jackson says is that may be true in law. She doesn't think so. It's a let them eat cake approach, but it's not true in life. Right? Race factors in life. We know that, and they are off or out to lunch with or without cake, I guess you could say. And it's an astonishing case. And the one possible opening that you perhaps were alluding to, Jay, there's a footnote in which they say all of these things that we've said very broadly may not apply to military academies. They don't say they don't apply or they do apply or why they don't apply. They just may not apply to military academies. So suddenly nobody can use race except West Point and Annapolis and others like the Coast Guard, Jay.
Maybe they did that for July 4th, for Independence Day, military kind of thing.
Now they snuck in, and this is really weird, that an individual applying to a college, because this is about elite schools and with many applicants, the individual can kind of bring race into an application statement, but the university can't use it in their decision. Huh? So to try to apply this in practice?
Impossible.
Impossible, and lots more litigation coming in all these categories.
What strikes me, though, as I mentioned, is that they're racist. Avi, I'm here to tell you they're racist. And they are trying to cover it up. They're trying to turn it around in this perverse way of finding, something else to call it. But you know what is a strange thing happening? Aside from the Indian reservation case, which I think is a small potatoes case in view of the number of people it reaches, as opposed to these other cases you've mentioned, and of course the gerrymandering case. Had they gone the other way on gerrymandering, it would have been really problematic for the country. And I think they saw it that way. I mean, it would have been a disaster, a destruction. And I don't think they wanted to do that, not for any philosophical reason, just for a practical concern. But aside from that, it seems to me that we know where they're going. We have known, you're right, for more than these recent cases. We have known for a couple of years where they're going. It strikes me that is a kind of precedent. We know they're going to be racist. You can expect they'll do it again. So we can predict their next case whenever that subject comes up.
Well, I'm not going to agree or disagree at this moment, but we can talk specifics because of that weird thing that they just said about an individual can sort of bring it in your statement, your individual statement, your personal statement. Who knows? But there will be litigation all over the place, and that, of course, used to be thought to be a problem. Famously, Alex Bickel talked about the passive virtues, and the court shouldn't use all its authority. Well, they're using all their authority and then going much further, as you pointed out, because their authority is supposed to require a case or controversy and standing and all those old rules. I want to say one other thing. You mentioned the Native American case. There is another one, just if you thought I was being too kind and velvet gloves here. There's a case involving a Navajo treaty. And the Navajo Nation was promised agricultural support, but they weren't promised access to water. So the court said in this case, well, you got agriculture. Who said water was part of that? And so they don't have a right to the Colorado River and so on. So they're not being so nice to the Navajo or other Native Americans all the time. There's one other, it's not a sigh of relief, but it was so absurd that when they finally didn't do it, I guess you could say, well, that was a pleasant, not surprise, because it was so outrageous. So there is a so-called theory or doctrine of the independent state legislature. And theory was, and this is out of North Carolina, well, actually, when we, the state of North Carolina, control elections, including the Electoral College, that means the legislature controls elections because the Constitution uses the word legislature. And that means that the North Carolina Supreme Court has no authority over what we want to do. So because that court, before it changed recently, struck down our racial gerrymander, they couldn't do that. Now, this doctrine, I unfortunately am co-author of a long article with many footnotes about this. This so-called doctrine or theory was around a little bit in the antebellum period. South Carolina, of all places, was the last state to reject it, but it had been rejected by the time of the Civil War. There's a case in the Plessy versus Ferguson courts era that says something. But everybody knows that's not what the case is about. Says something that can be used, that dictum can be used, and Rehnquist used it in his separate opinion in Bush versus Gore. That does not a doctrine or a theory make, but here we are. And of course, the court recognized, what do you know, judicial review, we're going to say the Constitution doesn't allow judicial review? What about our role? What about Marbury versus Madison? Which, of course, for the so-called textualists, not in the Constitution, judicial review on constitutional questions? Nope, there's no language about that. So John Marshall did that in 1803, and even this court wanted to protect its authority of the sort we've been talking about to pretty much call them like they see them, but they're not being umpires, which is what Robert said famously. That's all they do. He said that, don't worry about it. I'll just be like an umpire, just calling balls and strikes. Well, what we're talking about today, Jay, is an umpire just out of control, and I suppose both pitching and hitting at the same time.
Well, it was good they did Moore versus Harper that way. That was a good success for Neil Katyal, if you know him. He argued that case.
You mean it wasn't because of our 300 footnotes? Please.
Okay, all right. Oh, okay, now I got it. Nice work, Avi. So anyway, before we get back to some of the solutions, if any, on the admissions case, I want to spend a minute with you on the debt forgiveness decision. That is really dumping on 40 million people. It shows a disconnect. It shows an uncaring. It shows a complete unwillingness to deal, as you said, with the realities. And here now we leave all these people without any solution, and it's going to ruin their economic lives pretty clearly. What was the reason for that?
Well, again, they have this doctrine that they pretty much made up. It's true, the words have been used before, so it's not quite like the independent state legislature doctrine, used not in so many words before the Civil War. So this has been used in the 1930s, but it's still just sitting around. It's never been really the basis of a decision until they brush it off to narrow the Clean Water Act, I guess last term. So now we've got this doctrine. So now we've got this doctrine and we'll apply it. And we say, and this is in the name of democracy, that Congress has to approve something before an agency does it, if it involves a major question. And who gets to say what a major question is? Not Congress, not the bureaucracy. We, the court, tell you what is or is not a major question. And so here, we think they're out of control. We don't like agencies, and that's why we're going to do it. And we're going to do it, though there is really no standing in this case. And the fact that there are some states challenging, well, that used to be something that they just couldn't do. They couldn't come in and say, on behalf of our citizens, parens patriae, we've got standing. No, that didn't work. I mean, people tried that. Massachusetts tried that in challenging the court's refusal to take on the Vietnam War and talk about the power of Congress to declare war and not to do it through the Gulf of Tonkin resolution and other such dubious grounds. So no, it was clear. States didn't have standing. Well, states, southern states, western states, they clearly do have standing now if they want to object to some agency action. So it is pretty much out of control. And a major question doesn't define itself. The court will define it for us.
Well, what you're saying, what I think I'm getting out of this is they'll do what they want. They'll do what they want, and it has very little to do with logic or precedent. or what happened before, or the good of the country. They'll do what they want, and they are motivated. This supermajority is motivated by political considerations, political ideologies, and they can put a wolf in sheep's clothing, but the reality is they'll do what they want, and it's political. Am I right?
Well, I think you're right in the sense that, and this is what Sotomayor does so well in 303 Creative, and what Kagan does very well in the college loan case. And Roberts is sensitive to what she's doing because, and apparently they used to be pretty close, he and Kagan, but she takes some shots, deserved, as we've just been saying. And he basically says, oh, the court shouldn't be saying these bad things. Justices, even if they disagree, shouldn't, dirty laundry kind of argument. Well, I think if he's trying to show he's got control because he's more in the middle than the others, he's not convincing about that. And I think you're right that we are in a situation where the kinds of ideology, I don't think it's even politics. In a way, it's bad politics because they don't care what the polls say. They want to say, we're not up with the rest of the country about gay rights, let's say, to not get into the specifics of that. I mean, the case. So I haven't actually done this. Someone might ask me to, and apparently in the court papers, this is what you alluded to before, there was someone identified. They've now found that someone who said, what are you talking about? Wasn't me, I never asked. And in fact, I've been happily married to a woman for 15 years. So it's made up. And it's made up because they know who this court is. And it says, and this is what Sotomayor does wonderfully, I think, it says that the fact of access, which used to matter in terms of racial segregation, and the fact of dignity that used to matter, doesn't matter anymore, those values. It's stunning. It really is stunning.
Well, it's stunning that, you'd think if this happened at a lower court, you would expect it to be completely and absolutely reversed in the next appeal.
And let me say, there's no limiting language about this. And so, this is about someone in Colorado, but you can see, and because she's an artist, she says she's an artist, therefore she's an artist. You can say people are artists. Apparently Subway calls the people who fix the sandwiches artists. So who's to say? Is the court going to get into, oh, you really are an artist? No, you're not an artist? I'm an artist of the espresso machine. Every coffee shop now can make its own declaration as a First Amendment. I don't like those people. It's not even about religion. It's stunning.
Well, extraordinary that this is the same bunch of guys who are visibly corrupt and taking bribes and not owning up to that or even answering questions about it. I find it quite remarkable, and bad law, bad facts, bad process, the whole thing. And they expect people to, treat them as legitimate. I think it's going to get worse for them because they're going to get worse. You're going to see this again, Avi. I'm promising you right now, right here on ThinkTech. It's going to get worse, and that means their lack of, the lack of trust that the public have in them is going to get worse. But let me ask you about the admissions issue. There have been a number of commentators who said, well, you can get around that. You just you ask for an essay from every applicant, and then you figure out from the essay about whether this individual was disadvantaged, because it would be within that decision. It would be okay with that decision if you gave benefit to a person who came from a disadvantaged background. And then the people reading the essay could easily figure out what's what and give credit on the basis of that disadvantage. This is, and they'll do that. I'm sure I'm sure the schools will do that. And anybody worried about this decision, which in the business community, there could be other people worried about this decision having an effect on them. Just like the internet case could affect more than just an internet designer. It could affect cake bakers and everybody. So you find a way around it. And in fact, it's very interesting that in the abortion case, Dobbs, we had a lot of people trying to find a way around it, and some of them have, not good ways, but ways. And I think what we're having now, because of these impossible decisions, is a kind of chaos. All of these things suggest you got to find another resolution that sort of works around the corner, and it causes chaos. Your comment?
Well, to go back to public accommodations and its very long history in law, that was thought to be established. Now, who was in and who was out and how far it went? Because we know that Jim Crow, partly with the complicity of the Supreme Court, rose after Congress and the constitutional amendments post-Civil War tried to protect Blacks in particular, and they said so, full and equal benefit of all laws and proceedings, including public accommodations. Supreme Court basically invalidated that, the 1875 Civil Rights Act. They said, well, it's past time for Blacks to become citizens like everyone else, and they're not any longer wards, as they've been apparently for 18 years after the end of the Civil War. So stand on your own feet and don't complain about segregation and public accommodations. A horrible decision, which has haunted us ever since. But I think, getting back to your point, but a little variation, on this one, public opinion apparently has been against affirmative action, depends on how the question is asked. And that means there have been some popular referenda, most interestingly in Michigan and California, that said you can't use race, you can't do affirmative action. And those schools, those flagship universities in particular, tried to do something to get around it. And the figures are that it didn't work. That once you took that particular thumb off the scale, or whatever you want to call it, you didn't get the same number. Now, the case that did it is a made-up case by someone who has devoted much of his professional life to trying to get at affirmative action. And he alleged that it was about discrimination against Asian Americans. But there weren't Asian Americans in the case. So this gets back to your point. So they may be following public opinion to some extent in that case, but there may be ways around it. We shall see. That's one of the things, maybe chaos. Now, let me just put a specific local spin on this. I think ancestry is different from race. Law sometimes uses ancestry. If you die without a will, what do? We find out who your kin are. Well, that's kind of ancestry. So that's more positive in law than race. We have, of course, with Native Hawaiians, people who deeply believe in the importance of ancestry. And so that may be one possibility for Hawaii. Second point, it is the case that you can come up with something. We have a special program and we've had it since the school's beginning, and we're very proud of it, for people who otherwise wouldn't have gotten into law school. So they don't help our numbers if you're looking only at the LSAT scores. But what we now define that category to be is people who have overcome adversity and show promise of serving underserved communities. I think that's a pretty good definition, and it may even stand up. I hope we don't get sued. So far, we've had it in place for a while. No one sued us, but it may even stand up to the really ham-handed things that the court did in this case.
But it won't have the same large effect as the original program.
Yeah, this is North Carolina and Harvard. And I got to say one other thing. Harvard, they're very careful, lots of commissions and committees and studies, they can afford that. But they have a big Achilles heel, and that is they have 30-some thousand applicants, and they say we can fill every class many times over with people who are perfectly qualified. I believe that's probably true. However, a very high percentage of those who are admitted are in a special category they call deans and directors. And those are ones in which the deans and directors, the leadership of Harvard, have a special interest. And lo and behold, who do they turn out to be? They turn out to be people who've given big gifts, they turn out to be legacies, and they turn out to be athletes. Now, ironically, even among the athletes, because they have all sorts of sports that are largely white, even there, it's not really affirmative action in terms of race. But the other two categories clearly are not. And some of the commentators have said, what we're left with after the North Carolina case, which was added kind of last minute so that have the public as well as the private schools bound by this ruling or these rulings, even there, we have what? we have white affirmative action, if you look at that category. So we may not have racial affirmative action, who knows what race is, but we have, for those people who are well connected, Harvard may do that, at least so far.
Oh, talk about chaos. When I was in the service, they had affirmative action in the Coast Guard, and they would give direct commissions and the like to Black candidates. In fact, they would go and look for them, and they would put them within the ranks. And I assume they're still doing that. Now, you talk about that mysterious footnote about the military academies. You're also getting very close to affirmative action programs that are all through the military. And furthermore, my guess is there are affirmative action programs all through the federal government and maybe a lot of state governments. And so when you make a decision like this one, you're really just an inch away from striking affirmative action everywhere, including the United States federal government.
Well, and the military. They don't say the military, they just say the academies. Now, you can say that's because they're only talking about college admissions, but not necessarily. But you're absolutely right. And what is really important about your point is that the court, when they last upheld in one of the two Michigan cases, affirmative action, they paid attention to a brief written by someone in Hawaii on behalf of the military that said, we really think it's important. And that's what much of corporate America said. We really value this. That was 20 years ago. And O'Connor, who was the one who wrote that opinion, said, well, maybe we won't have to do this in 25 years. So the court says, well, a long time has passed, not quite 25 years. And so we're going to give up on it.
When they do things like that, you really wonder that they have their hand on the way the society is working, that they can say it's no longer necessary. Really?
Well,
how do you figure that?
I mean, that's where Jackson talking about what goes on in life, as well as what the court says goes on in law. And these are unusually, if I may use the term, parochial justices in terms of the world that they have known before they got on the bench. So it used to be that you had people who had more of the daily life and the push and shove of daily life in experience before they got on the court. And that is not true of particularly those who have been handpicked by the Federalist Society, which has had uncommon influence, shall we say, in staffing the federal courts and in particular the Supreme Court.
Yeah, and Trump did his best with what's his name in the Senate, running all those confirmations through as quickly as possible. And even in the last moments of the Trump administration, running Supreme Court justice confirmation through. So, to the extent that the Republicans lose ground, maybe they will lose ground over some of these cases, and there is no Republican president in 2024. Can this be corrected then? I guess you could change the supermajority at some point. You could have other judges appointed that would balance it. Is that likely to happen?
I don't think it's likely to happen, but I did a little bit of poking around. I've done some legal history, and there was at one point a 10th justice. And that point, it is interesting to note, was during the Civil War. So it's not like the country was united at that moment. And that was Justice Field. And Justice Field went on to hold the record for the most years served until William O. Douglas broke the record. So he served for 34 years and a few months, I think. So you said, well, how come we have 9 justices? Because it had fluctuated before the Civil War. And the answer is there may be proof in this historical example that just because you go to 10, it doesn't mean the next Congress or the next people are going to say, okay, we're going to go to 11. In fact, they very soon went to first 7 and then 9. And so we've had 9 ever since. But it's not a precedent that people have to be afraid of in the sense of, oh, there's no going back if we go to a 10th or 11th or 12th justice, whatever it is. They also were not always an odd number. They may have always been odd, but we've not had an odd number of justices throughout our history. So you could do that, but you would need Congress. You probably don't need a constitutional amendment for that. And one of the problems with that remedy or reform is you probably constitutionally would have to grandfather, as it were, the current justices. So they would all continue to serve.
And the flip side of this, if the Republicans won the presidency in 2024, whether it's Trump or anyone else who's conservative, their constituency would want them to keep appointing conservative judges, including any openings on the Supreme Court. So the supermajority could get to be an ultra supermajority from
Well,
6 to 7 to 8 to all 9 possible, right?
yes, but you never know. So FDR, who came off at the time, greatest election victory in American history, tried to add justices to the court. He did it in a very awkward way because he told the justices in the country that too many of them were too old to keep up with their work. And they answered and said, no, actually, that's not so. So he got pushback from the court itself. But a lot of his partisans split on that question of, can you pack the court? There's a recent book by Laura Kalman, who's a very good historian, that says, well, it wasn't so bad and he came close and so on. What happened was he got to change the court because there were deaths and resignations in the very few years really after 1936, 37, which was that period. And so the court is called the switch in time that saved 9. One justice switched sides. There's some argument that really he had already voted that way. But in any event, under the pressure of FDR and maybe the populace, the court did not continue in striking down progressive legislations they've been doing throughout the 1920s. And as the court was doing with vehemence against most of FDR's New Deal. So you never know about people's health, about people's resignations, and so on. But they are appointed for life, unless they're impeached, and no Supreme Court justice has ever been impeached. Well, that's
Maybe
not
it's
true.
time to start that now.
Never convicted. Never convicted.
Too bad. But let me ask you my last question, Avi. You know, we're trying to get a track on these guys. We look at every word they write, every word they say, everything in the press, every commentator, try to figure out what's really on their minds. It's as much a psychological examination as it is a legal one. And I just wondered, you know, you think that sometimes somebody who is appointed or elected to high office and who is really not worthy, in the course of his service or her service, they become worthy. They get the message. They realize who they're working for. They realize what the principles, the morality of this country really are, and they change and they become better. Now, I don't know if names come to mind about where that happened, but it certainly is a question I want to ask you about. You must think about that. Are any of these people capable of internal change?
Who knows, right? I mean, internal it's hard to measure that, but there are some very vivid examples over time on the Supreme Court. One of them would be Felix Frankfurter, who was known as a radical and certainly as progressive, and then he got on the court and pretty soon was the most conservative justice, or one of the 2 most conservative justices on the court. And he was one who really thought the passive virtues was important. We should stay out of these controversies. On the other side, one of the reasons that the Republican Party is so, one might even say beholden, but so enthusiastic to the Federalist Society is they believe that they had a few major disappointments, starting, I suppose, with Harry Blackmun, but also with Justice Souter. So they kept having Republican appointees who turned out not to be following, as it were, the party line, or at least the conservative party line. So there are many examples of justices who changed. Will any of these? It's a little hard to speculate as to which 1 or 2 it would be. And as you say, it's a supermajority, so it would take more than just one. I don't know. I can't do the curbside psychoanalyst.
I can.
I know.
I'm not a law professor, so I can.
Right.
And my prediction here is that none of them are going to change, and their legitimacy is going to be increasingly questioned. Their cases are going to be worse and worse, and they'll continue to do corruption. And that's because I am not an optimist about such things. And it's really too bad because they are one of 3 branches of government, and God knows where we go.
They start with God being invoked at the beginning of the court session. So maybe God is watching.
Okay, a little prayer just before July 4th. Maybe that'll help. Thank you very much, Avi. Avi Soifer, the a former dean of the William H. Richardson School of Law and a constitutional law professor now as we speak, and who thinks about this all day. And thank you so much, Avi.
Thank you. Always a pleasure, Jay. Good to talk to you.
Aloha.
Thanks so much for watching ThinkTech Hawaii. If you like what we do, please click on the like and subscribe buttons on YouTube. You can also follow us on Facebook, Instagram, and LinkedIn. And please check out our website, that's thinktechhawaii.com. Mahalo.